Oh, Mr. Tsoti, I am told reliably that he's going to take an oath. Okay, then I will read the oath to you. Then when the copy that is in front of you, you will sign it after you have taken the oath. Let me read the oath to you. In accordance with Section 16 of the Powers, Privilege and Immunities of Parliament and Provincial Legislators Act 2004, as a witness to this oversight inquiry, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a house or a committee may not be used against you in any court or place outside Parliament, except in a criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privilege and Immunities of Parliament and Provincial Legislature Act, a person who willfully vanishes a house or a committee with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath or an affirmation. As you have already said, you are going to take an oath. Therefore, I want you to go to the second page of the oath and swear that the evidence that you shall give shall be the truth, the whole truth, and nothing but the truth. And you say, so help me God.
I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. You sign, therefore, the document in front of you. I will now give over to the evidence leader to lead us in this session. Over to you, Advocate Vanar.
Thank you, Chair. Good morning to yourself, the honorable members, your guests, and colleagues. Mr. Tsoti, for the record, can you please state your full names?
Zola Andile Tsoti.
You have, upon receipt of an invite from the committee, furnished the committee with a statement which is dated 21 November 2017. It is an 8-year, we left here this morning. Please excuse my incoherence. It is 8 pages. In our discussions, you indicated to me that you would want to be afforded an opportunity to read the statement. And I had agreed to that. And I would like to afford you an opportunity to read your statement for the record.
Thank you, and good morning to honorable members of this committee and to the guests present here today. And thank you, Advocate, for giving me the opportunity to read my statement, which reads as follows. I feel privileged to have been afforded the opportunity to appear before this committee so that I may make my contribution towards the unraveling of the issues that have contributed to the current state of affairs at Eskom. The lapses in good governance, in good corporate governance, that have been occasioned by poor decision-making have opened up the company to exploitation by unscrupulous rent seekers. Those of us who have been and continue to be at the forefront of these events, including any who may have even peripheral knowledge thereof, have both the responsibility and moral obligation to voluntarily provide this knowledge to this committee and to the nation. In accordance with the information I received, that Eskom will make available any documentation I may require in support of my preparation for my appearance before this committee, I regret to say, despite numerous requests, Eskom did not avail me a single document. I have therefore had to rely on my memory of the pertinent events during my tenure at Eskom. This is unfortunate as it limits my ability to support the work of this committee. Be that as it may, I am here committed to presenting my recollections to the best of my ability. Honorable Chair, I now turn to the TNA contract, the New Age contract. On my arrival at Eskom in 2011, there was an existing New Age contract which was in progress. It was due to expire in about June 2014. At the time of its expiry, Colin Machila was acting chief executive. Mr. Machila acceded to the request that the contract be renewed. In so doing, he failed to apply a provision in the delegation of authority that enjoined him to deal with sponsorship through a committee that was put in place to deal with such matters, thus bypassing the process and acting outside of his delegated authority. The finance director, among others of his management team, raised objections to this action, contending that he used the wrong delegation of authority and that the correct one would require him to make a decision on sponsorship as part of a committee. Mr. Machila disputed this position and proceeded to sign the contract. A whistleblower reported this action to the chairperson of the Audit and Risk Committee, stating that the chief executive had flouted procurement regulations. The Audit and Risk chairperson then brought the matter to the attention of the board, which duly delegated the same Audit and Risk Committee to institute an audit inquiry into the matter. The Audit and Risk Committee appointed Sizwe Ntsaluba Gobodo, who produced a report with the finding that Mr. Machila had interpreted his delegation of authority incorrectly by using a wrong process to award the TNA contract, thereby infringing the provisions of the PFMA in that his authorized expenditure would then be irregular. Mr. Machila then requested the board to seek legal opinion in this matter, to which the board agreed. The legal opinion was provided by the firm of Ledwaba Mazwai attorneys, who upheld the Sizwe Ntsaluba Gobodo findings that Mr. Machila had acted outside of his delegated authority and recommended that the board discipline the acting chief executive. At this point, Mr. Machila was no longer with the company, as the substantive chief executive, Mr. Matuna, was then in office. so the board could not institute disciplinary action after the fact. Further, the lawyers advised that cancellation of the contract would result in expensive litigation and serious losses to the company. They also forwarded the board advice that that meant accepting the contract, that is, rectifying it, meant accepting the responsibility for Mr. Machila's breach. After deliberations, the board accepted this advice as an irregular expenditure finding was too ghastly to contemplate. The board then resolved to let the contract run the remaining few months of the extension. I now move on to the T-Systems IT procurement. I had established a practice of having regular weekly briefing meetings with the chief executive. At the time of the procurement of the IT services, Mr. Machila was acting chief executive. It was in one of these meetings that I was, for the first time, informed that there was an IT services procurement process in progress to replace T-Systems' contract. I next learned from the report of the board tender committee to the board that the process had hit an impasse in that negotiations with the preferred bidders were unsuccessful. Consequently, the recommendation to the board tender committee was to extend the T-Systems contract for a further 2 years. To the best of my recollection, circumstances of this suspension of Mr. Saleha were never raised at the board, neither before nor after the suspension. I'd like to comment briefly on the matter of the Duva boiler. Here, Chairperson, the procurement process of the Duva boiler was started after my time at Eskom. So regrettably, I therefore have no knowledge of this particular matter. I would now like to turn my attention to the suspension of the 4 executives. In order to do justice to the matter of the circumstances surrounding the suspension of Mrs. Matuna, Koko, Morokani, and Mulife, please indulge me to sketch some of the events that occurred prior to this, which events take us to the time of the appointment of the new board in early December 2014. During the first 6 or so weeks, the new board members were busy with the inductions and only started to get to grips with Eskom's business towards the end of January 2015. In the period from the arrival of Minister Brown at Public Enterprises Department in May 2014 till the new board was in place, I had been trying to cultivate a working relationship with the minister and aspired to achieve one similar to how I related with the previous minister, Gigaba. It became patently clear to me that I was not succeeding in this regard when the minister called me to a meeting a day or two before the State of the Nation address in February 2015. At this meeting, the minister stated as follows, and I quote, "Chairman, I have received complaints from management and board members that you are interfering in management. Please refrain from doing so, because if you don't, I shall have to find someone else to do your job. My response was, and I quote, "Minister, most board members hardly know what I look like, let alone not having worked with me yet. As for management, if scrutinizing their decisions and behavior and calling them to account constitutes interference with management, then I will happily continue doing so. If you had acceded to my request that we have regular briefing sessions, even this meeting would not have been necessary," close quote. Whereupon the minister responded by saying, and I quote, "Chairman, you go and do what you have to do. I will go and do what I have to do. There is no reason for you and I to talk about anything," close quote. And this is how the meeting ended. The very same afternoon, I was approached by Tony Gupta, who requested that we meet. At the meeting, Tony told me, and I quote, "Chairman, you are not helping us with anything. We are the ones who put you in the position you are in. We are the ones who can take you out," close quote. My response was, and I quote, "Do what you have to do and let me carry on with the job that the cabinet appointed me to do," close quote. And so ended that meeting. It is at this time that I felt that some sinister clouds are gathering, because the coincidence of the two events was not lost on me. Our first board meeting was scheduled for the 26th February 2015. On the evening of the eve of the meeting day, I received a phone call from the President of the Republic of South Africa, who informed me that he had tried to get hold of the minister and the deputy minister to no avail. The President said he was able to locate the acting Director General and asked if she had spoken to me, which at that point she had not. The President then informed me that the board meeting will not be taking place, and that the acting Director General will call me to postpone it. Shortly thereafter, I received a call from the acting Director General to say that the minister had asked that the meeting be postponed. When I asked for the reasons for the postponement, I was told that the minister had not given any. I then had the postponement communicated to the board members. The totality of these events had generated some apprehension in me about things to come. Hardly a week later, I was called by Dudu Mien. She said that I should avail myself for an audience with the President and declined to discuss any details over the phone. On or about 7th of March 2015, I arrived at the Durban presidential residence and was met by Dudu Myeni, her son Talent, and a certain Mr. Nick Linnell, who was introduced to me as a lawyer. Ms. Myeni then proceeded to outline the purpose of the meeting, namely that the situation of Eskom's financial stress and poor technical performance warrants that an inquiry into the company be instituted. She further elaborated that in the course of the said inquiry, 3 executives, namely Acting Chief Executive Tshidiso Matuna, Group Executive for Group Capital Dan Marokane, and Group Executive for Commercial Machela Koko, are to be suspended. I found this matter altogether shocking and proceeded to question the need for suspending these executives, as I saw this as a recipe for inducing instability in the company. She retorted that even the war room was experiencing frustration with the decline in performance of the company, and that the inquiry was essential. In her view, the suspension of the executives will not create difficulties because it will be explained that they are not being accused of wrongdoing, but are being asked to allow space for the inquiry to proceed unencumbered by their presence. Shortly thereafter, the president entered. After some pleasantries, he requested to know what was up for discussion, whereupon Ms. Myeni repeated what she had previously stated. The president then inquired if I knew who the executives are who were to be suspended, to which I responded that I would prefer that I consult the human resources rules of the company to check if there is provision for recusal rather than suspensions to achieve the same objective. Ms. Myeni stated that Mr. Linnell had assisted her with a similar situation at SAA and is being made available to assist. Mr. Linnell then proceeded and then proposed that he draft a resolution for me to present to the board, setting out the rationale for the inquiry. The meeting ended. I convened a board meeting on 9th March 2015, where I presented the proposed resolution. The board expressed its discomfort with this approach and instead proposed that the minister be invited to engage on this matter with the board. The board meeting with the minister in attendance was convened on the 11th of March 2015. The minister gave her support for the inquiry, as well as for the suspensions of the 3 executives. The board then resolved to proceed with both the inquiry and the suspensions of the 3 executives. It also mandated Audit and Risk Committee to prepare the terms of reference for the inquiry, as well as the People and Governance Committee to effect the suspensions. At the inception of the People and Governance Committee meeting, following the board meeting, two astonishing events occurred. Firstly, Dr. Ben Gubane stated that the name of the financial director must be added to the list of executives to be suspended. I immediately raised furious objections. For one, this executive's name was not among the names approved by the board. More importantly, suspending the finance director is going to generate shockwaves even internationally, especially with our investors and lenders, because the financial director is seen as the custodian of their investments. Dr. Ngubane responded that the minister had instructed that the financial director's name be added. I immediately called the minister to raise my concerns and objections, but she rebuffed me. The second astonishing event had to do with the appointment of the executives who had to act for those suspended. Hardly an hour after the end of the board meeting, which decided on the suspensions, Ms. Twaita Mabude was announcing the names in the People and Governance Committee of the executives who were going to act. I immediately protested that nobody in the committee, Ms. Mabude included, other than myself, would have known which executives were suitable replacements. Once again, Dr. Ngubane stated that these names came from the minister. Mr. Linnell assisted the People in Governance in drafting the suspension letters, which were then individually handed out. I was at pains to assure all the executives that had there been any provision for their recusal other than suspension, we would have preferred to apply it. And also that their suspension does not mean they have been found guilty of any wrongdoing. The following morning, 12 March 2015 at 10 o'clock, I addressed a press conference wherein I announced the suspension of the 4 executives and the company's intention to institute an inquiry. The afternoon of the same day, I was to have the most unpleasant and humiliating experience in all my tenure as chairman. The head of Eskom Treasury informed me that our investors and lenders from across the world will be calling in to ask for an explanation of the actions of suspending the executives. Indeed, I was online with around 52 individuals trying to defend what essentially was an indefensible position. Hardly a week went by, and I was faced with having to defend myself against accusations from several board members that I was not consulting the board in the preparatory work on the inquiry. The board engaged a law firm to trump up charges against me that I'm not fit to be a director of the company. On 23rd March, in the dead of night, I was given an ultimatum by the board to resign or be charged with lack of fitness to be a director. I resigned under duress. The termination of the services of the executives who left Eskom occurred after I had left. In conclusion, Honorable Chairperson, I would like to state here that corruption is the scourge that is denying our people the opportunity of a decent and prosperous livelihood. It is the duty of all of us to rid our society of this evil. I therefore applaud the initiative taken by this Honorable House to get to the bottom of the maladministration at state-owned enterprises. I wish the committee well in this endeavor. And that is my statement, Honorable Chair. Thank you.
Thank you.